Good morning students. Today we are going to discuss about the kinds of partnership and types of partners. Kinds of partnership. Generally, partnership can be divided on the basis of duration. There are two categories of the partnership which can be divided on the basis of duration are partnership at will under section 7 and particular partnership under section 8. While forming a partnership, if there is no clause about the expiration of such a partnership, we will call it as a partnership at will. Section 7 of Indian Partnership Act of 1932 deals with this kind of a situation. Partnership at will has been defined as follows. When there is no provision in partnership agreement for the duration of their partnership or the determination, that is dissolution of their partnership, then that partnership is called as partnership at will. If there is an agreement between the partners about the duration or the determination of the firm, that will not be the partnership at a will. But if a partnership was entered into a fixed term and continues to operate beyond this term, it will become a partnership at will from the expiration of that particular term. The special feature of a partnership at will is that partnership may be dissolved by any partner by giving a notice in writing to all other partners of his intention to dissolve the partnership under section 43 subclause 1. And the second feature is the partnership will be dissolved from the date which is mentioned in the notice as the date of the dissolution, and if no date is mentioned, then from the date of the communication of such notice under section 43 subclause 2. So, in this particular kind of a partnership at will, any partner who is a partner in the partnership firm is free to dissolve the partnership at his own will by giving notice to all other partners of his intention of a dissolution, and that particular date will be considered as a date of a dissolution which is mentioned in the notice, or if such no date is mentioned, the date of the communication of such notice to all other partners in the partnership firm. When a partnership can be formed for a carrying or a continuous business, or it can be formed for one particular venture or undertaking, that particular partnership is called as particular partnership under section 8. Particular partnership. When the partnership is created or formed for completing any project or undertaking or for a particular period, that is for a fixed term, then such particular partnership is called as particular partnership under section 8. Such partnership comes to an end on the completion of a project or a venture or undertaking or on the expiry of the time period. If such partnership is continued even after the expiry or the completion of a venture, it is deemed to be a partnership at will under section 7. A partnership may be dissolved before the expiry of the term or the completion of the venture only by the mutual consent of the partners. So herein under section 8, the notice or the clause of a notice is not mandatory, which has to be given by the particular partner in the partnership firm. So if after the completion or if the term has been fixed by the partners or the member of the partnership firm, then after the completion or after the expiry of that particular term, the particular partnership will come to an end. So take for example, if a producer is producing a movie, so if he is going to form a partnership for that particular period, so after producing the film, after the completion of the film, that particular partnership will comes to an end. Under section 17 subclause B, it provides that if the firm is constituted for a fixed term and continues to carry on the business after the expiry of that term, then the partnership will become the partnership at will, and mutual rights and the duties of the partner will remain same as they were before the expiry. So once the term has been continued, or even after the completion of the term, if the partnership is going to be continued by the members of the partnership firm, then automatically or it will be deemed to be considered as a partnership at will under section 7, and whenever that particular partnership has to be dissolved, again the section 7 the provisions of the section 7 has to be followed by all the partners by giving notice of their intention to dissolve the partnership under section 43 subclause 1 and 2. Now we are going to look upon the types of partners. The member of a partnership firm is called as a partner. It is not mandatory that all the partners are the same and all the partners to participate in the conduct of the business or share the profit or the losses equally. The partners are classified depending upon the nature of the work, the extent of liability, etc. So basically there are 6 types of partners which we are going to discuss now. So the first type of a partner is active partner or a managing partner. Active partner is also known as ostensible partner. As the name itself suggests that he takes active participation in the firm and the running of the business. He carries on the daily business on behalf of all the partners. This means that he acts as an agent of all other partners on a day-to-day basis and with regard to all ordinary business of the firm. Hence, when an active partner wishes to retire from the firm, he must give a public notice about the same, and this will absolve him of the acts done by the other partners after his retirement. Unless he gives a public notice, he will be held responsible or liable for all the acts even after his retirement. And the second type of a partner is dormant partner or a sleeping partner. This kind of a partner is a partner who does not participate in the daily functioning of the partnership firm, that is, he does not take any active part in the daily activities of the firm. He is, however, bound by the action of all other partners. He will also continue to share the profit and losses of the firm and even bring in his share of capital like any other partner. If such a dormant partner retires, he need not give any public notice of the same of his retirement. Then the third type of a partner is nominal partner. Nominal partner is a partner who does not have any real or a significant interest in the partnership firm. So, in the essence, he is only lending his name to the partnership firm. He will not make any capital contributions to the firm, and so he will not have a share in the profits either. But the nominal partner will be liable to outsider and the third parties for the act done by any other partners or all the partners. Then the fourth category of a partner is partner by estoppel. If a person holds out to another that he is a partner of the firm, either by his words, action or conduct, then such partner cannot deny that he is not a partner. This basically means that even though such partner is not a partner, he has represented himself as such, and so he becomes a partner by estoppel or partner by holding out. Fifth category of a partner is partner in profits only. This kind of a partner will share only the share of the profit of the firm. He will not be liable for any liabilities. Even when dealing with the third parties, he will be liable for the acts of the profits only. He will share none of the liabilities. Then the last category or the type of a partner is minor partner. A minor cannot be a partner of a firm according to the Contract Act. However, a partner can be admitted to the benefits of the partnership If all the partner gives their consent for the same, he will share the profits of the firm, but his liability for the losses will be limited to his share in the firm. Such a minor partner, on attaining majority, that is becoming 18 years or attaining at the age of 18 years, has 6 months to decide if he wishes to become a partner of the firm. He must then declare his decision by giving a public notice, so whether he continues as a partner or decides to retire. In both cases, he will have to issue a public notice. Thank you.